The government of the United States of America is the federal government of the Republic of 50 states that constitute the United States, as well as one capital district, and several other territories. The federal government is composed of three distinct branches: legislative, executive and judicial, whose powers are vested by the U.S. Constitution in the Congress, the President, and the federal courts, including the Supreme Court, respectively. The powers and duties of these branches are further defined by acts of Congress, including the creation of executive departments and courts inferior to the Supreme Court. The full name of the Republic is the United States of America. No other name appears in the Constitution, and this is the name that appears on money, in treaties, and in legal cases to which it is a party. The terms Government of the United States of America, or United States government, are often used in official documents to represent the federal government as distinct from the states collectively. In casual conversation or writing, the term federal government is often used, and the term national government is sometimes used. The terms federal and national in government agency or program names generally indicate affiliation with the federal government. Because the seat of government is in Washington, D.C., Washington is commonly used as a metonym for the federal government. History. The outline of the government of the United States is laid out in the Constitution. The government was formed in 1789, making the United States one of the world's first, if not the first, modern national constitutional republic. The United States government is based on the principle of federalism, in which power is shared between the federal government and state governments. The details of American federalism, including what powers the federal government should have and how those powers can be exercised, have been debated ever since the adoption of the Constitution. Some make the case for expansive federal powers while others argue for a more limited role for the central government in relation to individuals, the states or other recognized entities. Since the U.S. Civil War, the powers of the federal government have generally expanded greatly, although there have been periods since that time of legislative branch dominance or when states' rights proponents have succeeded in limiting federal power through legislative action, executive prerogative or by constitutional interpretation by the courts. One of the theoretical pillars of the United States Constitution is the idea of checks and balances among the powers and responsibilities of the three branches of American government: the executive, the legislative and the judiciary. For example, while the legislative has the power to create law, the executive can veto any legislation an act which, in turn, can be overridden by Congress. The President nominates judges to the nation's highest judiciary authority, but those nominees must be approved by Congress. The Supreme Court, in its turn, has the power to invalidate as unconstitutional any law passed by the Congress. These and other examples are examined in more detail in the text below. Legislative branch. The United States Congress is the legislative branch of the federal government. It is bicameral, comprising the House of Representatives and the Senate. Powers of Congress. The Constitution grants numerous powers to Congress. Enumerated in Article I, Section 8, these include the powers to levy and collect taxes, to coin money and regulate its value, provide for punishment for counterfeiting, establish post offices and roads, issue patents, create federal courts inferior to the Supreme Court, combat piracies and felonies, declare war, raise and support armies, provide and maintain a navy, make rules for the regulation of land and naval forces, provide for, arm and discipline the militia, exercise exclusive legislation in the District of Columbia, and to make laws necessary to properly execute powers. Over the 2 centuries since the United States was formed, many disputes have arisen over the limits on the powers of the federal government. These disputes have often been the subject of lawsuits that have ultimately been decided by the United States Supreme Court. Makeup of Congress, House of Representatives. The House currently consists of 435 voting members, each of whom represents a congressional district. The number of representatives each state has in the House is based on each state's population as determined in the most recent United States Census. All 435 representatives serve a 2-year term. Each state receives a minimum of 1 representative in the House. In order to be elected as a representative, an individual must be at least 25 years of age, must have been a U.S. citizen for at least 7 years, and must live in the state that he or she represents. There is no limit on the number of terms a representative may serve. In addition to the 435 voting members, there are 6 non-voting members, consisting of 5 delegates and 1 resident commissioner. There is 1 delegate each from the District of Columbia, Guam, the Virgin Islands, American Samoa and the Commonwealth of the Northern Mariana Islands, and the resident commissioner from Puerto Rico. Senate. In contrast, the Senate is made up of 2 senators from each state, regardless of population. There are currently 100 senators, who each serve 6-year terms. Approximately 1/3 of the Senate stands for election every 2 years. Different powers. The House and Senate each have particular exclusive powers. For example, the Senate must approve many important presidential appointments, including cabinet officers, federal judges, department secretaries, U.S. military and naval officers, and ambassadors to foreign countries. All legislative bills for raising revenue must originate in the House of Representatives. The approval of both chambers is required to pass any legislation, which then may only become law by being signed by the President. The powers of Congress are limited to those enumerated in the Constitution. All other powers are reserved to the states and the people. The Constitution also includes the Necessary and Proper Clause, which grants Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Members of the House and Senate are elected by first-past-the-post voting in every state except Louisiana, California and Washington, which are runoffs. Impeachment of federal officers. Congress has the power to remove the President, federal judges, and other federal officers from office. The House of Representatives and Senate have separate roles in this process. The House must first vote to impeach the official. Then, a trial is held in the Senate to decide whether the official should be removed from office. Although 2 presidents have been impeached by the House of Representatives, neither of them was removed following trial in the Senate. Congressional Procedures. Article I, Section 2, Paragraph 2 of the U.S. Constitution gives each chamber the power to determine the rules of its proceedings. From this provision were created Congressional Committees, which do the work of drafting legislation and conducting congressional investigations into national matters. The 108th Congress had 19 standing committees in the House and 17 in the Senate, plus 4 joint permanent committees with members from both houses overseeing the Library of Congress, printing, taxation and the economy. In addition, each house may name special, or select, committees to study specific problems. Today, much of the congressional workload is borne by subcommittees, of which there are some 150. Powers of Congress. Congressional Oversight. Congressional oversight is intended to prevent waste and fraud, protect civil liberties and individual rights, ensure executive compliance with the law, gather information for making laws and educating the public, and evaluate executive performance. It applies to cabinet departments, executive agencies, regulatory commissions and the presidency. Congress's oversight function takes many forms: committee inquiries and hearings, formal consultations with and reports from the President, Senate advice and consent for presidential nominations and for treaties, House impeachment proceedings and subsequent Senate trials, House and Senate proceedings under the 25th Amendment in the event that the President becomes disabled or the office of the Vice President falls vacant. Informal meetings between legislators and executive officials, congressional membership. Each state is allocated a number of seats based on its representation in the House of Representatives. Each state is allocated 2 senators regardless of its population. As of January 2010, the District of Columbia elects a non-voting representative to the House of Representatives along with American Samoa, the U.S. Virgin Islands, Guam, Puerto Rico and the Northern Mariana Islands. Executive Branch. The executive power in the federal government is vested in the President of the United States, although power is often delegated to the cabinet members and other officials. The President and Vice President are elected as running mates by the Electoral College, for which each state, as well as the District of Columbia, is allocated a number of seats based on its representation in both houses of Congress. The President is limited to a maximum of 2 four-year terms. If the President has already served 2 years or more of a term to which some other person was elected, he may only serve one more additional 4-year term. President. The executive branch consists of a President and those to whom the President's powers are delegated. The President is both the head of state and government, as well as the military commander-in-chief and chief diplomat. The President, according to the Constitution, must take care that the laws be faithfully executed, and preserve, protect and defend the Constitution. The President presides over the executive branch of the federal government, an organization numbering about 5 million people, including 1 million active duty military personnel and 600,000 Postal Service employees. The 44th and current President is Barack Obama. The President may sign legislation passed by Congress into law or may veto it, preventing it from becoming law unless 2/3 of both houses of Congress vote to override the veto. The President may unilaterally sign treaties with foreign nations. However, ratification of international treaties requires a 2/3 majority vote in the Senate. The President may be impeached by a majority in the House and removed from office by a 2/3 majority in the Senate for treason, bribery, or other high crimes and misdemeanors. The President may not dissolve Congress or call special elections but does have the power to pardon, or release, criminals convicted of offenses against the federal government, enact executive orders, and appoint Supreme Court justices and federal judges. Vice President. The Vice President is the second highest executive official in rank of the government. As first in the U.S. presidential line of succession, the Vice President becomes President upon the death, resignation, or removal of the President, which has happened 9 times in U.S. history. Under the Constitution, the Vice President is President of the Senate. By virtue of this role, he or she is the head of the Senate. In that capacity, the Vice President is allowed to vote in the Senate, but only when necessary to break a tie vote. Pursuant to the 12th Amendment, the Vice President presides over the joint session of Congress when it convenes to count the vote of the Electoral College. While the Vice President's only constitutionally prescribed functions, aside from presidential succession, relate to his or her role as President of the Senate, the office is now commonly viewed as a member of the executive branch of the federal government. The U.S. Constitution does not expressly assign the office to any one branch, causing scholars to dispute whether it belongs to the executive branch, the legislative branch, or both. Cabinet, executive departments and agencies. The day-to-day enforcement and administration of federal laws is in the hands of the various federal executive departments, created by Congress to deal with specific areas of national and international affairs. The heads of the 15 departments, chosen by the President and approved with the advice and consent of the U.S. Senate, form a council of advisors generally known as the President's Cabinet. In addition to departments, a number of staff organizations are grouped into the Executive Office of the President. These include the White House staff, the National Security Council, the Office of Management and Budget, the Council of Economic Advisers, the Council on Environmental Quality, the Office of the U.S. Trade Representative, the Office of National Drug Control Policy and the Office of Science and Technology Policy. The employees in these United States government agencies are called federal civil servants. There are also independent agencies such as the United States Postal Service, the National Aeronautics and Space Administration, the Central Intelligence Agency, the Environmental Protection Agency, and the United States Agency for International Development. In addition, there are government-owned corporations such as the Federal Deposit Insurance Corporation and the National Railroad Passenger Corporation. Judicial branch. The judiciary explains and applies the laws. This branch does this by hearing and eventually making decisions on various legal cases. Overview of the federal judiciary. Article 3 Section I of the Constitution establishes the Supreme Court of the United States and authorizes the United States Congress to establish inferior courts as their needs shall arise. Section I also establishes a lifetime tenure for all federal judges and states that their compensation may not be diminished during their time in office. Article 2 Section 2 establishes that all federal judges are to be appointed by the President and confirmed by the United States Senate. The Judiciary Act of 1789 subdivided the nation jurisdictionally into judicial districts and created federal courts for each district. The three-tiered structure of this act established the basic structure of the national judiciary, the Supreme Court, 13 courts of appeals, 94 district courts, and 2 courts of special jurisdiction. Congress retains the power to reorganize or even abolish federal courts lower than the Supreme Court. The U.S. Supreme Court adjudicates cases and controversies matters pertaining to the federal government, disputes between states, and interpretation of the United States Constitution, and, in general, can declare legislation or executive action made at any level of the government as unconstitutional, nullifying the law and creating precedent for future law and decisions. The United States Constitution does not grant the judicial branch the power of judicial review. The power of judicial review was asserted by Chief Justice Marshall in the landmark Supreme Court case Marbury v. Madison. There have been instances in the past where such declarations have been ignored by the other two branches. Below the U.S. Supreme Court are the United States Courts of Appeals, and below them in turn are the United States District Courts, which are the general trial courts for federal law, and for certain controversies between litigants who are not deemed citizens of the same state. There are 3 levels of federal courts with general jurisdiction, meaning that these courts handle criminal cases and civil lawsuits between individuals. The other courts, such as the bankruptcy courts and the tax court, are specialized courts handling only certain kinds of cases. The bankruptcy courts are under the district courts, and as such are not considered part of the Article 3 judiciary, and also as such their judges do not have lifetime tenure, nor are they constitutionally exempt from diminution of their remuneration. Also, the tax court is not an Article 3 court. The district courts are the trial courts wherein cases that are considered under the judicial code consistent with the jurisdictional precepts of federal question jurisdiction, and diversity jurisdiction, and pendent jurisdiction can be filed and decided. The district courts can also hear cases under removal jurisdiction, wherein a case brought in state court meets the requirements for diversity jurisdiction, and one party litigant chooses to remove the case from state court to federal court. The United States Courts of Appeals are appellate courts that hear appeals of cases decided by the district courts, and some direct appeals from administrative agencies, and some interlocutory appeals. The U.S. Supreme Court hears appeals from the decisions of the Courts of Appeals or state Supreme Courts, and in addition has original jurisdiction over a small number of cases. The judicial power extends to cases arising under the Constitution, an act of Congress. A U.S. treaty. Cases affecting ambassadors, ministers and consuls of foreign countries in the U.S. Cases and controversies to which the federal government is a party. Controversies between states and foreign nations. And bankruptcy cases. The 11th Amendment removed from federal jurisdiction cases in which citizens of one state were the plaintiffs and the government of another state was the defendant. It did not disturb federal jurisdiction in cases in which a state government is a plaintiff and a citizen of another state the defendant. The power of the federal courts extends both to civil actions for damages and other redress, and to criminal cases arising under federal law. The interplay of the Supremacy Clause and Article 3 has resulted in a complex set of relationships between state and federal courts. Federal courts can sometimes hear cases arising under state law pursuant to diversity jurisdiction, state courts can decide certain matters involving federal law, and a handful of federal claims are primarily reserved by federal statute to the state courts. Both court systems thus can be said to have exclusive jurisdiction in some areas and concurrent jurisdiction in others. The U.S. Constitution safeguards judicial independence by providing that federal judges shall hold office during good behavior. In practice, this usually means they serve until they die, retire, or resign. A judge who commits an offense while in office may be impeached in the same way as the president or other officials of the federal government. U.S. judges are appointed by the President, subject to confirmation by the Senate. Another constitutional provision prohibits Congress from reducing the pay of any Article III judge. Relationships between state and federal courts, separate from, but not entirely independent of, this federal court system are the court systems of each state, each dealing with, in addition to federal law when not deemed preempted, a state's own laws, and having its own court rules and procedures. Although state governments and the federal government are legally dual sovereigns, the Supreme Court of the United States is in many cases the appellate court from the state Supreme Courts. The Supreme Courts of each state are by this doctrine the final authority on the interpretation of the applicable state's laws and constitution. Many state constitution provisions are equal in breadth to those of the U.S. Constitution, but are considered parallel. A state Supreme Court, other than of its own accord, is bound only by the U.S. Supreme Court's interpretation of federal law, but is not bound by interpretation of federal law by the Federal Court of Appeals for the Federal Circuit in which the state is included, or even the federal district courts located in the state, a result of the dual sovereigns concept. Conversely, a federal district court hearing a matter involving only a question of state law must apply the substantive law of the state in which the court sits, a result of the application of the Erie Doctrine. However, at the same time, the case is heard under the Federal Rules of Civil Procedure, the Federal Rules of Criminal Procedure and the Federal Rules of Evidence instead of state procedural rules. Together, the laws of the federal and state governments form U.S. law. Elections and voting. Suffrage, commonly known as the ability to vote, has changed significantly over time. In the early years of the United States, voting was considered a matter for state governments, and was commonly restricted to white men who owned land. Direct elections were mostly held only for the U.S. House of Representatives and state legislatures, although what specific bodies were elected by the electorate varied from state to state. Under this original system, both senators representing each state in the U.S. Senate were chosen by a majority vote of the state legislature. Since the ratification of the 17th Amendment in 1913, members of both houses of Congress have been directly elected. Today, U.S. citizens have almost universal suffrage from the age of 18, regardless of race, gender, or wealth. The only significant exception to this is the disenfranchisement of convicted felons, and in some states former felons as well. Under the U.S. Constitution, the national representation of territories and the Federal District of Washington, D.C., in Congress is limited. Residents of the District of Columbia are subject to federal laws and federal taxes, but their only congressional representative is a non-voting delegate. Residents of U.S. territories have varying rights. For example, only some residents of Puerto Rico pay federal income taxes. All federal laws that are not locally inapplicable are automatically the law of the land in Puerto Rico, but their current representation in the U.S. Congress is in the form of a resident commissioner, a non-voting delegate. State, tribal and local governments. The state governments tend to have the greatest influence over most Americans' daily lives. The 10th Amendment to the United States Constitution prohibits the federal government from exercising any power not delegated to it by the states in the Constitution. As a result, states handle the majority of issues most relevant to individuals within their jurisdiction. Because state governments are not authorized to print currency, they generally have to raise revenue through either taxes or bonds. As a result, state governments tend to impose severe budget cuts at any time the economy is faltering, which are strongly felt by the public for which they are responsible. Each state has its own written constitution, government and code of laws. The Constitution stipulates only that each state must have a republican government. Therefore, there are often great differences in law and procedure between individual states, concerning issues such as property, crime, health and education, amongst others. The highest elected official of each state is the governor. Each state also has an elected state legislature, whose members represent the voters of the state. Each state maintains its own state court system. In some states, Supreme and lower court justices are elected by the people. In others, they are appointed, as they are in the federal system. As a result of the Supreme Court case Worcester v. Georgia, American Indian tribes are considered domestic dependent nations that operate as sovereign governments subject to federal authority but, generally and where possible, outside of the jurisdiction of state governments. Hundreds of laws, executive orders and court cases have modified the governmental status of tribes vis-à-vis individual states, but the two have continued to be recognized as separate bodies. Tribal capacity to operate robust governments varies, from a simple council used to manage all aspects of tribal affairs, to large and complex bureaucracies with several branches of government. Tribes are empowered to form their own governments, with power resting in elected tribal councils, elected tribal chairpersons, or religiously appointed leaders. Tribal citizenship and voting rights are typically restricted to individuals of native descent, but tribes are free to set whatever citizenship requirements they wish. The institutions that are responsible for local government within states are typically town, city, or county boards, water management districts, fire management districts, library districts and other similar governmental units which make laws that affect their particular area. These laws concern issues such as traffic, the sale of alcohol and the keeping of animals. The highest elected official of a town or city is usually the mayor. In New England, towns operate in a direct democratic fashion, and in some states, such as Rhode Island and Connecticut, counties have little or no power, existing only as geographic distinctions. In other areas, county governments have more power, such as to collect taxes and maintain law enforcement agencies. See also: President, Cabinet, Executive Order, Federal Executive Departments, President's Executive Office, Line Item Veto, Courts, Bankruptcy Courts, Courts of Appeals, District Courts, Federal Courts, Federal Judicial Circuit, Federal Judicial District, Supreme Court, Law, Constitution, Governmental designations for places, U.S. Code, U.S. Law, Agencies. Note: most agencies are executive, but a few are legislative or judicial. Federal agencies, independent agencies, states and territories, political divisions, U.S. states, U.S. territory, works and websites, copyright status of work by the U.S. government web portal for businesses, U.S. government web portal for citizens. References. Bibliography: Wood, Gordon S. The Creation of the American Republic, 1776–1787. Gordon S. Wood, Institute of Early American History and Culture. PA 653. ISBN A0-8078-2422-4. External links: USA.gov, the official U.S. government portal. United States Government, a research information guide from the University of Illinois at Urbana-Champaign Library. Government information, directories and manuals, web resources provided by GovPubs at the University of Colorado Boulder Libraries.